a DOJ moment nobody predicted. Every once in a while, a piece of legal news breaks that is bigger than the headlines it generates. It changes how courts think, how agencies behave, and how attorneys begin to frame arguments that have been stuck in the margins for decades. That is what happened when the Department of Justice declared that a nearly 100-year-old federal gun control law, 18 U.S.C. 1715, violates the Second Amendment and cannot be enforced against constitutionally protected firearms. And this wasn't a judge. It wasn't the Supreme Court. It wasn't Congress. It came from within the executive branch itself, specifically the Office of Legal Counsel, which is the legal brain trust that advises presidents, attorneys general, and federal agencies on constitutional interpretation. And it matters more than casual gun owners might realize, because the question wasn't just whether someone can mail a handgun. It was whether the government can block Americans from acquiring, transporting, and maintaining firearms that are used for lawful purposes. If those rights are recognized, other doors suddenly open. Before we get into what's next, we need to understand what just happened and, for a moment, forget the headlines and look at the legal mechanics inside this decision. They're stronger than the hype and more dangerous to the old regulatory order than most analysts have admitted. Small ask before we dive in. If you care about breaking legal updates and how they shape your rights in the real world, make sure to subscribe. It helps more than you think. Section 1. A federal law finally collapsed. The law at the center of this story is 18 U.S.C. 1715. Passed in 1927, it criminalized mailing pistols, revolvers, and similar concealable firearms through the United States Postal Service. And unlike many obscure gun statutes, this one had teeth. Postal inspectors could seize the gun, report you, and trigger federal criminal charges. For almost a century, the law survived not because courts upheld it, but because no one seriously challenged it under modern Second Amendment rules. That changed with a challenge supported by Gun Owners of America and the Gun Owners Foundation. The legal theory was simple. If the Second Amendment protects firearms in common lawful use, especially for self-defense, the government cannot make it practically impossible to transport, acquire, or maintain those firearms without a historically recognized justification. In the post-Bruin world, laws from the 20th century don't get an automatic pass. The DOJ finally admitted the obvious. There is no historical tradition supporting a federal ban on mailing handguns, and the purpose of the statute was openly hostile to the Second Amendment. Short takeaways. 1715 was outdated. It violated Bruin's historical test. It burdened rights beyond mere possession. The DOJ formally acknowledged the conflict. Section 2. Why the DOJ spoke first. Most legal battles involving gun rights begin in the courts, then climb through appeals until the Supreme Court either takes the case or lets it die. But this time, the executive branch made the first move. The Office of Legal Counsel doesn't issue memos casually. These are constitutional interpretations that agencies are expected to obey until Congress or the courts say otherwise. That makes this episode unusual for 3 reasons. First, the DOJ admitted a federal gun statute is unconstitutional. That has rarely happened in American history. Second, they applied the Bruin framework correctly, looking at text, history, and tradition, instead of the interest-balancing test courts used before 2022. Third, they signaled that ancillary rights like transport, shipment, acquisition, training, repair, and maintenance are embedded in the Second Amendment, even though they aren't spelled out word for word in the text. This matters because most modern gun laws don't ban ownership outright. They make it difficult to carry, maintain, transport, or acquire firearms. The DOJ just weakened that regulatory strategy in one stroke. Section 3. History and tradition finally won. Bruin reset the Second Amendment battlefield by replacing 50 years of balancing tests with a historical inquiry. Instead of asking whether a law is reasonable or good for public safety, courts must ask whether it fits within the American historical tradition of firearms regulation. For 1715, the answer was straightforward. The founding era and the 19th century had no similar bans on mailing, shipping, or transporting handguns. In fact, handguns were commonly transported through commerce, trade, and private mail systems. DOJ's memo also confronted something courts have danced around for years. The 1927 law wasn't passed to regulate safety, it was passed to suppress commerce in handguns. Under the Bruin test, hostile motives matter, and they make the statute's constitutionality collapse even faster. Precedents that support this framing include Heller, 2008, Protection of Arms in Common Use; McDonald, 2010, Incorporation into the States; Caetano, 2016, Modern Arms are covered; Bruin, 2022, Historical Tradition Test; Range, 2023 CA3, Burden must align with history. In hindsight, 1715 was legally doomed the moment Bruin was handed down. Section 4. The Ancillary Rights Breakthrough. This DOJ memo will be remembered for one specific doctrinal recognition. You cannot meaningfully keep and bear arms without the ability to transport, acquire, repair, and maintain them. The memo listed each of these implicitly protected activities and tied them to historical sources and Supreme Court language. Why is this big? Most state gun control in 2026 relies on choking off the activities around gun ownership, not gun ownership itself. Permit delays, waiting periods, training restrictions, and FFL choke points are built around preventing Americans from acquiring or maintaining firearms. If DOJ's interpretation holds, any law that effectively blocks gun acquisition or transport becomes constitutionally vulnerable. That logic would not only threaten 1715, it threatens multiple modern pillars of gun regulation. For the first time, the federal government embraced what legal scholars have argued for years. The Second Amendment protects more than the gun in your safe. It protects the process of getting it there. Section 5. Real-world scenarios force the issue. The OLC memo didn't read like an abstract legal opinion. It read like a travel advisory for gun owners. It listed concrete examples where transporting a handgun becomes impossible without mail or shipment, flying through New York airports with a lawfully owned handgun, breaking travel in Chicago and losing federal transport protection. Buses and rail systems refuse firearms as luggage. State lines where possession transforms from lawful to criminal mid-journey. These examples weren't rhetorical flourishes. They demonstrated a practical infringement on the right to self-defense recognized in Heller and strengthened in Bruin. The logic is brutally simple. If the government can prevent you from receiving a handgun, it can prevent you from exercising the right at all. That is why the memo's core conclusion matters. A right that cannot be exercised is a right that does not exist. Section 6. A slip opinion with teeth. The DOJ's decision came through what's called a slip opinion. Critics sometimes downplay those because slip opinions aren't statutes or court rulings, but that misses the point. Inside Washington, OLC slip opinions are binding on federal agencies unless overturned by Congress, the courts, or the Attorney General. They shape how the executive branch enforces federal law, how prosecutors file charges, and how regulatory agencies run their playbooks. In constitutional disputes, enforcement is half the battle. A law can stay on the books and still die if prosecutors refuse to file cases. That's what just happened to 1715. The statute wasn't repealed. It was stripped of enforceability. The more important takeaway is signaling. When OLC recognizes Second Amendment text, history, and tradition as binding on federal statutes, other agencies downstream will adopt the same analysis. That's how doctrinal shifts move through government without waiting for a Supreme Court case. Short takeaway bullets. Slip opinions are binding internally. Enforcement died, even if the law didn't. Agencies now inherit the Bruin test. A quiet structural shift just occurred. Section 7. What this means for federal gun law. Most state-level gun laws already face post-Bruin litigation, but federal statutes are a different arena. Until now, the DOJ rarely questioned its own regulatory inheritance. The OLC memo changes that dynamic by admitting that federal gun control enacted after the founding era lacks historical support. That matters because the oldest and most contested federal laws, the National Firearms Act, 1934, the Gun Control Act, 1968, the Hughes Amendment, 1986, and 922G, prohibitions did not survive a founding-era tradition test in any serious academic literature. They survived through deference, not doctrine. This memo cracks the door for challenges to interstate transport restrictions, FFL choke points, NFA travel permissions, registry-style reporting, ammunition shipping limitations, handgun roster systems, state level, training mandates not grounded in history. None of these is guaranteed to fall, but the government's own legal brain trust just validated the core theory behind those challenges. Burden plus no tradition equals unconstitutional. For gun rights litigators, that is fuel. Section 8. The NFA question comes into focus. No one at the DOJ said the words NFA out loud, but the subtext isn't subtle. If restricting how a handgun is mailed violates the Second Amendment, what do you call a system that forbids interstate travel of registered items without federal pre-permission? That's the structure of the National Firearms Act. The memo explicitly recognized three ancillary rights: the right to acquire, the right to transport, the right to maintain. NFA restrictions hit all three simultaneously. Before 2022, courts treated those restrictions as reasonable regulations. After Bruin, reasonableness is irrelevant. History controls, and the historical record for federal tax registration of ordinary arms is barren. Legal observers are already predicting that NFA cases in 2026 to 2027 will use this memo as an exhibit, not as precedent but as confession. If the executive branch now concedes that hostile purpose and lack of historical analog are fatal, the NFA's foundations look thin. Short takeaways. The memo strengthens NFA litigation. Transport rights matter more than expected. The DOJ unintentionally broadened the battlefield. Section 9. State gun control just lost a shield. For the last decade, state governments defended aggressive gun control by arguing that courts had not clearly defined ancillary rights. If states could block acquisition, training, or commerce without banning possession outright, they could avoid strict scrutiny. Post-Bruin, that shield has been cracking. The OLC memo shatters it further by framing these activities as necessary predicates to bearing arms. Once the federal government admits that acquiring a gun is part of the Second Amendment's protected scope, states lose the ability to hide regulation behind procedural obstacles. The immediate pressure points are handgun rosters, permit-to-purchase systems, mandatory training schedules, ammunition purchase checks, multi-month waiting periods, sensitive place expansions, FFL bottlenecks, and zoning games. These systems rely on friction. The memo reframes friction as infringement. Section 10. A Supreme Court set up without a case. The last major shift to Second Amendment doctrine came through Bruin, but Bruin didn't define everything. It left unresolved questions for future cases, including: are ancillary rights textually protected? Can federal law survive without historical tradition? Are public safety interests irrelevant permanently? Do hostile motives matter constitutionally? Is transport a dimension of bearing arms? The DOJ memo doesn't resolve those issues, but it tees them up for the court. It gives lower courts permission to read the Second Amendment more broadly. It gives litigators ammunition to argue purpose, not just burden. And it gives the Supreme Court a preview of the argument that may shape the next decade. Rights that cannot be exercised meaningfully do not exist meaningfully. That kind of groundwork matters. Constitutional revolutions rarely happen in one case. They happen in increments until the final case writes the doctrine that the others implied. A shift larger than the headlines. This story will be told as a win for GOA, and it is. It will be told as a win for gun owners, and it is that too. But historically, it's something bigger. It is the first time in modern history that the executive branch has adopted the full Bruin logic and used it against a federal gun statute that had survived unchallenged for nearly a century. That is how constitutional orders change. Not with one dramatic Supreme Court ruling, but through a sequence of acknowledgments. Congress denies tradition, courts restore tradition, the DOJ applies tradition, states recalibrate, and eventually the Supreme Court finishes the job. Whether you are a constitutional scholar, a gun owner, or just someone who follows legal shifts, this moment is not routine. It is a sign that the Second Amendment is no longer a museum artifact. It is a living right being retranslated into modern life. If you want to stay ahead of these updates where law, politics, courts, and real-world gun ownership intersect, make sure to subscribe and share this video with someone who cares about these rights as much as you do. We have a lot more coming.